Hello, and welcome to Brinks Hofer Gilson and Leon's virtual panel presentation entitled Patent Reform, What Should You Be Doing Now? I am pleased to be joined by today's presenters, Tim Delaney and Eric Sosinko. Our panelists' biographies and today's presentation can be found on the top left of your screen. Click there to download them at any time during the program. And now, today's presentation, Patent Reform, What Should You Be Doing Now?
We're thrilled to give you some updates on what's going on with patent reform and to give you some indications of what you should be doing now in the area of dealing with these new patent law changes. I am primarily a trial litigator, and I think Eric mostly does patent prosecution, so we're going to give you perspectives from both areas today and try and give you some good background on what you should be doing now. Now, what we'll be addressing, of course, is the American Invents Act, which was signed into law last September. It is by far the most dramatic change that I've seen in my career, and really that patent law has seen in the last 50 years. It's an attempt to try and harmonize United States with the laws throughout the world. In addition, there's a number of big changes in terms of first to file, elimination of best mode as a defense in patent litigation, a much broader sense of prior art that can be applied, and some very new post-grant procedures to address the validity of issued patents. Post-grant review, inter partes review, supplemental examination. And also we'll address some of the provisions that were inserted into the law to address what people felt were abuses in patent litigation. So there's a lot of procedures in there now, a lot of new laws that are very pro-defendant. We're going to touch on those as well this afternoon. That includes prior user rights, restrictions on joinder, willful infringement, and false patent marking. So why don't we get started? Each of the patent reform law changes become effective on 3 different discrete dates. Consequently, you need to operate going forward with each of those dates in mind so that you're operating with ones that are already effective, ones that will be effective, and ones that will be effective even later. This summary I will attempt to answer, what should you be doing right now? And since this question's the answer to that question is going to change over time, we expect to provide follow-up webinars at 4 months and 8 months from now to give you an idea of what you should be doing at those points in time, which is probably going to be somewhat different than what you should be doing right now. These are the things that we're going to be discussing today. First, we're going to talk about the variety of law changes that have already changed. These happened last September. We're going to briefly go through them, explain what you should be doing now to respond to those. And then we're going to talk about the changes that are coming online in September, a variety of different things, very important changes. But even though they don't come into effect in September, we believe there's things you should be doing right now to address them, and we'll provide that guidance. Finally, the real change, the real huge change, are effective in March of next year. That includes the first inventor to file and derivation proceedings, and we'll also address those. And are there things you should still be doing right now to get ready for those, even though we're still about more than a year or less than a year out from when they'll become effective. So why don't we start with inter partes reexamination. It's being replaced. If you want to file one, you've got to do it before September, or forever you'll never have another opportunity to do it. And it's going to be replaced by inter partes review. Our advice would be don't wait. Do not wait for inter partes review. It's going to make some major changes which are not necessarily favorable to someone who wants to contest an issued patent. The fees are going to go up, way up. Right now you can file an inter partes reexamination for $8,800. That's going to go up to $27,200, and far more if you're going to be attacking more than 20 claims. In fact, if you look at the rules that they've proposed, and again, it's not final, they could change these numbers, but right now that's what they're looking at. They've got estimates for a lot of claims going up to as much as $100,000. So if you want to file and save some money, the time to do it is now. Also, there's a far harsher estoppel with inter partes review than there is currently with inter partes reexamination. Right now, if you file an inter partes reexamination and you lose, maybe you win on some claims, but you don't win on all of them, and you don't want to appeal for whatever the reason would be, you could file an ex parte reexamination and address whatever claims were left over. You could do cleanup that way. You're not going to be able to do that with inter partes review. Moreover, if you file an inter partes reexamination, you can enjoy a very lengthy stay of litigation. Inter partes reexaminations are done in special dispatch, but they can go on for quite some time. Inter partes review are going to be limited. They're supposed to be done in a year, or at most for 6 months thereafter. So it's going to be a shorter pendency. Also, inter partes review isn't going to be available for certain circumstances. If you had a litigation that's been pending for so long, you're not going to be able to file it. There is no such limitation with respect to inter partes reexamination. Now, apart from that, there's a new threshold that's already effective for inter partes reexamination. They've changed this threshold from substantial new question of patentability to a reasonable likelihood that requester will prevail in invalidating a claim, at least one claim. And the reason Congress did that is they felt that reexamination was far too lenient in terms of granting requests. The grant rate was about 95%, and the idea was if we change the standard, maybe we can reduce the burden on the Patent Office and get less of these requests granted. So far, however, the new standard has made little change. The Patent Office is struggling with the new standard, not quite sure how to give it more teeth than the old standard. So consequently, the grant rate is very similar. But there is an increased focus on the substantive merits of proposed rejections. So this is a strategy that we recommend for inter partes reexamination. Remember, you got to file it before September 16th this year, and we think you should if you're considering inter partes. And you have to address the new threshold. You want to provide and justify claim constructions in your initial requests and explain why there should be rejections. And you might want to give some more material. You may want to give an expert declaration to provide more information on claim scope or more explanation of the prior art, just to give a little bit more detail, a little bit more information, make the Patent Office's job easier in getting over that new threshold. Now I'd like to talk about false patent marking. Again, this is something that's already in effect. It went in effect in September, and it now made it clear that if you've got a patent marking on your product where the patent is expired, that's not going to be a violation of the section. So that's the most common thing that occurs is for example, you put the patent number in a mold. It's tough to replace the mold, and frequently there were for long-lasting products, you'd have a patent on there that had expired, and there was a lot of false patent litigation as a consequence. Well, that's no longer an issue. Those are not going to be a violation under the section. Moreover, nobody can just file a false patent marking now. You basically have to be a competitor. You have to have a competitive injury. And you're going to have to, if you file a false patent marking, you're going to have to show competitive injury, which is very difficult to do. It basically took the teeth out of this statute. Typically, false patent marking, it's only going to be filed by the U.S. government, and historically they have not enforced this section. So, you know, in terms of enforcement, what you're likely to see now is counterclaims and patent litigation and so forth, but a lot of the teeth have been taken out of it. Another thing that went into effect right with the false marking was virtual patent marking. That's available now. You can use it right now, and it is a great new way to avoid false marking and to provide constructive notice that you have a patent on a patented article so that you can get damages going back from before the time when you provide actual notice. We think it's a great idea that if you've got patents on products, you should be moving to a virtual patent marking system because there's a lot of great advantages. All you have to do is put on the product the fact that there's a patent or patent pending provided with a website address. And then the website address has to be freely accessible to the public and identify the patent numbers that are associated with an article. There's a couple of examples I'd like to point out where companies have done that. And for example, with Callaway Golf, there's a site that Callaway put together where they list their products. And this is it here, showing on the screen. And they put in some promotional material, but then they have a list of their products, and they have a list of the patents associated with it. So in one fell swoop, they've provided adequate notice. They're going to be able to go back and collect damages if there's an infringer before they provide notice. And they're going to provide good, adequate notice to the public of marking patents that covered on their products. For example, if you look at here, it shows the Razor Fit driver. They've got a design patent. They've got a utility patent. And they say there's additional patents pending. So it's all right there. And it's a very convenient, easy way to provide a complete marking for their products. We go back to the next one. I think I've got another example from another one. Okay, here's Idaho Technology. Similar, they've got a simple website. And if you scroll down, they again associate the patents that are associated with their various products. What are the part numbers? What are the product names? What are the patent numbers? It's a very simple thing to set up and to do it, and it's effective for handling their obligations under the patent marking statute. So if we could go back to the presentation now. Nope, went too far, unfortunately. We go back one, please. Thank you. You still need to be diligent in patent marking, but virtual patent marking makes it a lot easier. Now, courts may require a higher degree of precision, seeing how it is so easy. I mean, you shouldn't have mistakes on that website, but you should set up processes to update the site on a regular basis. There's a variety of subcontractors that are out there that will do that for you and keep active on it. But we recommend that you do that and set it up, and keep a log of your changes to show that you've kept this information up and kept it regular. But it's a great new change that should make everyone's life a lot easier. Another big change is prioritized examination. This is also already effective. And what it does is it speeds up the whole process of patent examination. There's a 12-month target to final disposition. You can, if you file it, it's going to be a very quick prosecution. And it's going to cost some money. You're going to have to pay about $4,800 in addition to the usual fees. But as a consequence, you'll get this special enhanced status that you can get your applications dealt with. And that special status will end at the variety of different places. After there's a notice of allowance, final office action, you file a request for continuing examination, notice of appeal. There's a number of things that will happen which will cut it off. But until those items happen, you're going to have a very quick process. However, there's a limit. The Patent Office is concerned when they instituted this that they were going to get overwhelmed. So they put a limit of 10,000 per fiscal year, which runs from October to September. And what we found is, I don't think they're going to hit their quota. We've looked at it, I think, for example, from 2012, which started October, about half a year's gone by. They haven't even got halfway through the quota. There's about, I think they're up to about 1,400, 1,500 applications that have used this. But here's what's happening. They're doing them quick, real quick. They're responding to the request for special status very quickly, and once it's granted, they're dealing with the applications in a very quick process. So you're getting to after it's implemented, it's over a little bit over a month, and you're going to get a final office action. That's compared to 35 months to a final office action with typical applications. So it's working. The process is working. So we recommend, we don't know if this quota, right now the quota looks like it's not going to be a problem, but who knows in subsequent years. So we recommend you file it early in the fiscal year. Make sure you do it before the quota is exceeded. And then every time you have an application, you should do a cost-benefit analysis. Does the speed that you're likely to get justify the extra cost, the extra $5,000? Is there a known infringement? Then maybe there is a good justification. Are there licensing opportunities? Are there some competitive advantages? Are you a startup where you need to get some quick patents, foundational patents? Do you have a fast-moving technology? I mean, it's a good opportunity if one of these things applies that you might want to use this. I know that our firm has filed a number of these in the last several months, and so far our experience has been very positive. There's another big change, which may be a big change or may not be a big change, depending on what's going on in the Supreme Court. As many of you may know, there's a cert was granted in the Supreme Court, Hyatt v. Kapos, which is determining the standard of review for cases that go to district court out of the patent office. And depending on how that is determined, may have a big impact on how big this change is. But what the change is making, if you're appealing an action of the patent office, whether to grant a patent or certain other factors, that you can either go to the Federal Circuit or you can go to the District Court. And previously, you'd go to the District Court in the District of Columbia. I think that was typically the reason because that's where the patent office used to be, but it hasn't been there for years. It's been in Virginia, Eastern District of Virginia, and now this act corrects that anomaly. So if you're going to go against the patent office and file a district court action, you're going to have to now be in the Eastern District of Virginia, which for patentees is typically a good place to be because it's the fastest court in the country, and it's considered to be very favorable to patentees. So you might want to consider going there. And the reason people do go to district courts is because the standard of review in the Federal Circuit goes from one where it gives deference to the PTO if you go straight from the PTO, goes to de novo if you come out of the district court. But again, that Supreme Court decision may change that. Supreme Court decision may continue the deference, so it may not be as important. But we'll find out when the Supreme Court comes down. The next big change we'd like to talk about is the change in joinder. That was effective as of last September. And now you can no longer join all sorts of defendants in one litigation. You can't just say, well, they infringe the same patent, so I've named, anywhere from 5 to 10 to, in some cases, hundreds of defendants have been added in a single action. You can't do that anymore because if it's just the fact that they might infringe the same patent is not going to be considered the same transaction, the same occurrence. It has to relate now to the same accused product or process. So a favored tool of NPEs, which was to name all these different defendants in a single venue, they can't do it. So it's basically made patent litigation more expensive and more difficult for companies that wanted to name a bunch of parties in a single location. Now they're going to have to wage multi-front patent war. The venue calculus has changed also because now when you named a bunch of parties, it was very hard to get transfer because maybe some of the parties the forum was convenient. If it wasn't convenient for others, you couldn't just split up the case because you had to move the whole case. Now that has changed. So now it's a little bit different than what it was. Now defendants are going to have to decide, well, now that they're going to have to file all these different suits, do we want to consolidate them or do we want to keep them separate? And I think defendants are coming to different views on that. For example, a number of them have requested multi-district litigation, where you go to one district and decide a lot of the basic, the claim construction, you handle discovery in a multi-district single court, and then go back to the individual courts for trial. And there's been some that have done that. Some defendants are saying, no, we want to make the plaintiff go through its paces, run through all these things in different courts throughout the country. We think the effect on transfer is probably better for defendants. You're no longer linked with defendants who might be in a convenient position in a forum. You now have to go somewhere else. But keep in mind that this rule on joinder does not apply to the ITC. So we've already seen that NPEs and others are now going to the ITC because they can still put a bunch of defendants in a single action and proceed with them on that way. So that's putting some burdens on the ITC, and that's continuing. Now I'll turn it over to Eric.
Thanks, Tim. Excuse me. Another provision that's currently in effect is the tax avoidance strategies have been deemed not to be patentable subject matter. Basically, this relates to any tax strategy that might be employed to reduce, avoid, defer tax liability. That brings up the question, what are they referring to as tax liability? Basically, tax liability has been defined very broadly. Tax liabilities are going to be any tax that might be incurred under a federal law, a state law, a local law, or even the law of any foreign jurisdiction. The way that they instituted this was not to put tax strategies as not falling under the scope of patentable subject matter in Section 101. Rather, they deemed that all such avoidance strategies will be insufficient to differentiate a claimed invention from the prior art. So basically, they're saying tax avoidance strategies are all known at this point in time, regardless of whether the patent, or rather the tax law is in effect at this point in time or in the future. At first, when I heard about this, I thought it was a fee generation or revenue generation mechanism. However, the more you think about it, it's actually the reverse. The rationale here is really that we all have to deal with federal law and we all have to interpret federal law. So the idea is that patents directed to interpreting law, we're going to restrict people from complying with the law or being able to do what they would like to do with their interpretation of law. So people should be able to interpret and apply the law as they see to it. So that's the rationale behind this. There are some exclusions that, in case you have your technology being brought into this category, there are specific exclusions that will not fall under a tax avoidance strategy. These relate to methods, apparatuses, technologies, computer program products, or systems that are used for preparing tax returns or tax filings. Included in that is systems that relate to the recording, the transmitting, as well as the organizing of the data that also relates to that. Additional exclusion goes to financial management. So if the system or the method or the technology relates to financial management, it's not going to fall under the category and be unpatentable as well. In that regard, however, you have to make sure that the financial management strategy is severable from any tax strategy and that it's not limited to using that tax strategy. So going forward, if you're involved in financial products and things like that nature, it's important to focus on the exclusions to make sure that your applications are not going to be deemed a tax strategy. You want to couch the invention in terms of financial management, make sure it's severed from the tax strategies. And also we recommend rather, that we avoid trigger language. Languages in your claims that are going to be tax, fee, duties, tariffs, as well as the opposing side, which would be the liability, the charges, or the obligations. Another currently enacted section of the AIA relates to human organisms. Section 33 of the AIA specifically states that no patent may issue on a claim that is directed or encompassing a human organism. That's a pretty broad statement right there. And it applied to any application that was pending on the date of enactment, but it did not apply to any patent that had already issued prior to enactment. So with that broad language, it draws into question, well, what actually is being excluded and what is permitted? Well, the language in the Act itself is very broad. However, the intent of the Act was to bring in a body of pre-existing PTO policy. So basically, the legislative history goes through and helps define what a human organism is. Generally, that's going to be what we would most likely think of it. It's a human organism at any stage of development. It could be an embryo, a fetus, infant child, or an adult. And it doesn't matter by the means with which the human organism is generated or created. Could be through natural production or through technological methods, which is the more likely one in the patent sense. The legislative history also goes into further detail so that there is a broader list of non-prohibited technologies. These relate to chemical compounds and compositions. That nature would be nucleic acids, polypeptides, antibodies, hormones, things along those lines, as well as cells and tissues, body components, as well as stem cells, stem cell tissue lines, and things along those natures. Importantly, synthetic organs are not going to be considered part of the human organism prohibition. The methods as well for creating and modifying or treating a human is not going to be prohibited as well. Those include enhancing fertility and in vitro fertilization as well, and the implanting of the embryos. One final thing on that is non-human organisms are not prohibited. So if there's a combination of genes from a human organism and we have a transgenic animal, then that's not going to be prohibited. So if you are in the medical arts and you're dealing with something that may fall into this category, it's important that you avoid that classification directed to human organisms. So take a hard look at the claims, look at the broadest possible interpretation that you might have of those claims, and make sure that it's not going to be able to encompass a human organism. Clearly, you want that language to be beyond that scope. One of the major provisions that I think people are talking about anyway of the AIA is Section 15, which relates to the best mode. As we all know, there is a requirement that in your patent application, you must disclose the best mode for practicing the invention. That stays in under the AIA, so the requirement is retained for putting it in your patent application. However, the consequences for violating that requirement are no longer there. So on the enforcement side of the patent, there's a change. On the prosecution side or the acquisition side of the patent, there's not a change. So this requirement, as we all know, is unique to the United States. The rest of the world has gotten rid of this already. And this is just one step towards harmonization that we have. If you look at the other things that are going on under the AIA, you will see a common theme of harmonization. The thing it does from the consequences for violating it on the defense side, it's going to reduce and simplify the issues that are involved during litigation and ITC proceedings. That in turn will help reduce costs during litigation. The further thing it does is it does help reduce the burden on inventors for record keeping with regard. So, as I said, the best mode requirement is still there for the drafting of the patent application and during the prosecution. So during the application stage, the examiner is free to apply those requirements. And there are some provisions that you can find at the PTO's website which gives guidelines for the examiners on how to interpret best mode and how to apply it. Once the patent issues, that stage, again, best mode is not a defense to infringement. It's not going to be a means for invalidating a patent during post-grant review, and it's not a means for invalidating a patent under inter-parties review. One further point to keep in mind regarding best mode is that if you're going to claim priority via a provisional application, rather the benefit of a provisional application, or the benefit of a filing date under the continuing applications under Section 120, The failure to have the best mode in either of those applications is not going to be a bar to your application going forward. So the practical elimination of the best mode, which meaning the enforceability of it, I think from a prosecution side of things is not too important, because we're still going to comply with it on the prosecution side of things. We still have to deal with the written description requirement. We still have to deal with the enablement requirement. And oftentimes, in dealing with those two requirements, the best mode comes up and comes into the play, and that's really maybe the way we have to deal with written description and enablement. Finally, from a patentability standpoint, putting the details in there surrounding your best mode is going to give you more hooks that we can rely on when we need to establish patentability. Another provision that took effect with the passage of the Act, in name only I should say, is microentity status. This is a benefit to independent inventors, early stage startup companies, as well as to institutions of higher education. It was long recognized that patent filing fees, especially for very early stage companies and independent inventors, can be sometimes problematic or difficult to come up with. So what they did was set the fees being 1/4 that of a large entity. So in effect, half of what would be a small entity. Just to give you a little bit of an example how dramatic this can be for a small entity, or rather a micro entity, is to take a look at some of the fees that are out there. The fees I have listed on the slide are those that are currently being proposed going forward, and the filing fee is set at $400. As you can see, micro entity can go to $100. The bigger ones, as you get down and look at, for example, the 7.5-year maintenance fee. That fee for a large entity is $3,600. For a micro entity, it's going to only be $900. So dramatic impact for small independent inventors and new stage startups. To qualify, one, they must qualify as a small entity, and the entity, or the inventor or applicant rather, cannot be named on more than 4 prior patent applications. Those exclude provisional applications, and they exclude foreign applications. The other criteria in order to qualify is the applicant must not have an income that is 3 times the median household income on the previous calendar year. The slide says 2011, gives an example of what that median income 3 times level was. It's actually the 2010 number there was about $165,000 of income. Finally, the applicant cannot have an obligation to assign it or license it, or cannot have already done that to an entity that does have 3 times the median household income. From a strategy perspective, this is really good if you can qualify for it. The important thing to note right now is these reduced fees have not taken effect. Once the Patent Office puts forward the new rules and they take effect, that's when the microentity status will really come into effect. The other thing I think from a strategy standpoint, because of the exclusions for provisional patents, the micro entities, the applicants thereunder, really should use provisional applications as a means to stay as a microentity for as long as they can. Also, the final thing to consider is whether or not, on an accounting side, whether or not you can shift income in a given year so that you do not exceed that 3 times median household income limitation. With that, we're moving towards items under the AIA that become effective this September, so I'll pass it back to Tim.
Thank you, Eric. The first one we want to talk about is pre-issuance third-party submissions. There is a procedure for that now, but it is expanded considerably. These things are things that a third party puts in the record that the examiner can consider and will be included in the record of the patent if a patent issues. And what can be provided is any published patent application or other printed publication of potential relevance. But in addition, what you can do now, what you can do in September, is provide a concise description of the asserted relevance of each document, which previously you could not do. However, there's some time limits on when you can actually do this. You've got to do it before the earlier of allowance or later of the first claim rejection or 6 months after publication, which is a lot more time than what you had previously. So the combination of a greater window to provide these potential materials to the Patent Office, plus the fact you can provide some explanation about why the material is relevant, is a big change and a big advantage. We recommend that you monitor your competitors' applications and consider whether or not you want to provide some submission like that. Do you really want your competitor to come out with a patent which you know to be invalid, where you have to end up fighting a litigation over it, whereas you have this very quick and easy way to do it by filing these third-party submissions. So we recommend that you go ahead and keep a monitor on what they're doing and take advantage of this new law when it comes into effect. There's also, you don't have to serve on the applicant, so it can be anonymous. You can file these submissions. So that's also a big advantage. So I think you're going to want to take advantage of this. If you're concerned about an application that's been filed and you want to try and prevent its issuance, you can take some easy steps. Another new change which is coming on in September is the citation of prior art. This is, any person at any time, so after the patent issues, for example, you can stick in prior art patents or publications which have a bearing on the patentability. But not just that, you can also include statements that the patentee has made with regard to claim scope. Say, for example, a patentee is communicating with you and telling you that, oh, we've got a real broad claim here, it reads on X, Y, Z, provided it's not under any confidentiality, you could file that in the patent file. And it's going to become a part of the official file. It's not going to do anything unless there's some post-grant activity. So it may end up being very valuable if there's later post-grant proceedings, either with you, the person that submits it, or maybe some third party who ends up being in the post-grant proceeding. Plus, it may provide leverage to you in settlement talks. Before you file this in the patent office, you say, listen, if you don't give me a license here, I'm going to file this information in the patent office, which is going to put a big cloud over your patent rights. They may be willing to prevent you from doing that as leverage in settlement. And again, it may provide material that could be used later by somebody else to invalidate the patent rights that could be done. And the submitter can't submit anonymously. The next one we want to talk about is the transitional period for financial business method patents. This also becomes effective in September, and it's available only to those that have been sued or been charged with infringement of a financial business method patent. And it's a nice provision if you've got that situation. There's broader prior art that's going to be available to you, not just patents and not just printed publications. There's less estoppel than what's going to be the effect of the other post-grant proceedings that are going to be in place. You can't re-raise what you've raised in the against the business method patent, but it's only going to be limited to the things that you've actually raised in the proceeding. And you can also file it longer than what you could do under the new post-grant proceedings that could be in place. Even if it's a year after suit is filed, you can get this review for financial business method patents. The other thing that is nice is it allows an interlocutory appeal if the district court refuses to stay the litigation. This is not something that's available typically. So if you file one of these proceedings and get it granted, you should be able to get the district court to stay the litigation. We think this is a no-brainer. It allows you to take a free shot in the patent office, stay the litigation, and we believe it reflects Congress and the court's hostility to these types of patents. it's an opportunity for you to take a shot at them if you're in the defendant position. If you're in the plaintiff position, you should be prepared to expect to receive some of these as soon as the law comes in online in September. Then there's 3 new post-patent issuance proceedings that are going to start in September 16, 2012. It's going to be a whole new world. These 3 new proceedings are in many ways very different than what exists now, very different than ex parte patent reexamination, very different than inter partes patent reexamination. And we believe you need to be prepared to deal with these. The first one we want to talk about is supplemental examination. This is a very controversial one. This is something that the patent owner requests. The patent owner would request this because maybe there's some stain on its patent that it wants to expunge. And this proceeding will allow them to do that. And assuming they get it granted, basically what they do is they file a request and claim that there's a substantial new question of patentability that should be considered, provide the explanation of why that is, and if it's granted, then there'll be basically a reexamination will take place. But if you do it, it permits curing. It cures for example, if there were some allegations of inequitable conduct and you file a supplemental examination and the patent comes out, it will be clean in future litigation from any kind of allegations from that standpoint. However, there are some problems with supplemental examination. One, it's going to be pretty expensive. It's over $5,000 to request a supplemental examination, and if the request is granted, there's going to be another $16,000 for the reexamination that will follow it. So here's some of the things that you should consider when you're considering whether or not to file one. It's not going to be limited to prior patents and publications, but it does provide that safe harbor. Do you have a patent you really like, but it's got some real inequitable conduct questions? Well, maybe that's a patent you should consider filing to get it cleaned. And patentees that are considering whether or not this applies to any of the patents that they hold should be thinking about it right now. They're going to want to hit the ground running in September of this year to get those proceedings started, to maximize the length of period of their patents that are going to not have these problems in their patents before they want to assert them. So we believe it makes some sense, even though it's expensive, even though you're going to have to somewhat criticize your patent in filing the request. Maybe it makes sense for patent rights that are pretty valuable but have some tarnish to them. And I'll pass back to Eric to discuss inter partes review.
As Tim said, beginning in September, we've got 3 different post-patent issuance proceedings that are coming into play. 2 of the ones that I'm going to talk about are post-grant review and inter partes review. There's a lot of similarities to them, but there are some distinctions to them, particularly in connection with the types of prior art that you can raise to try and invalidate the patent. Inter partes review, I'm going to speak about first, even though if we think in terms of the process and the life of the patent, post-grant review would come into play for the life of the patent a little bit earlier. The reason I think that you'll see as we go through this discussion is that post-grant review, even though it does become effective in September, it's effective in name only because we can only proceed against patents that have issued and have been filed under the first inventor to file provisions. Those provisions themselves do not kick in for another 6 months from September, so basically a year from now. And then it's an issued patent, so we're looking sometimes down the road from, some ways down the road from this September. We're probably looking at a minimum 3.5 years before we actually start to see post-grant review really pick up and really get an idea of where everything's going to go under that. But inter partes review comes into effect this September, and it can be applied to any patent that is currently issued or any patent that issues after September. As Tim said a little while earlier, inter partes review will be replacing inter partes reexamination. And again, we do think from a cost perspective, inter partes reexamination might be the best way to go right now. As he did indicate, inter partes review is going to be significantly expensive, at least right now under the proposed fees. It is over $20,000 to institute this. But if you take a look at it and realize that this is a replacement for litigation, then the fees kind of become a little bit more justifiable. But for those of us who strictly or most of the time deal with prosecution, seeing a $20,000 fee is something that we're not just accustomed to seeing. Anyway, proceeding with inter partes review, inter partes review is going to be conducted a little bit differently. One, it's not going to be conducted with an examiner to start with. Inter partes reexamination starts with an examiner. Inter partes review will start with the Patent Trial and Appeal Board and a set of administrative law judges there. So you'll start with 3 judges that are going to be hearing your case. If you have already filed a civil action challenging validity, you're not going to be able to proceed with inter partes review. And you're not also, because of the timelines you'll see in the slides there, you can't proceed with inter partes review if post-grant review has already been instituted. You'll have to wait until that is over as well. Inter partes review can be requested 9 months after a patent issues. Once we get into the full flow of inter partes review, the patent will issue 9 months for post-grant to be instituted. If no post-grant is instituted, then we'll proceed into inter partes. You will have to identify all the grounds that you're going to challenge the patent on for each claim. You will have to identify the real party in interest, and you're going to have to provide the evidence to support your challenge, not just allegations at this point in time. The grounds for review under inter partes is going to be more narrow than what we'll see under post-grant review. It's strictly grounds under 102 and 103, so it's novelty and obviousness, and again, it's just going to be based upon prior art patents and printed publications. The general procedures were set out in the AIA. They've been flushed out a little bit more in the proposed rules. We'll still have to see exactly where the proposed rules go. But generally how it's set out under the AIA is that the patent owner, once this is instituted, will have an opportunity to file a preliminary response to the petition. A difference here from inter partes reexamination is the patent owner can file his statement and, in effect, try to prevent the instituting of inter partes review. Under inter partes reexamination, the patent owner does not get to voice their opinion as to whether the proceedings should go forward until it's already been instituted. So there is an ability on the side of the patent owner to try and head off the inter partes review by filing that preliminary response. There will be discovery in inter partes review, which is a little bit different, and with discovery, which we'll talk a little bit more in one of the further slides below, it's basically depositions of people that are signing affidavits and witnesses along those lines. There's nothing that I've seen yet to indicate that there will be live testimony from any of the witnesses, that it'll just be written evidence that we'll put into based on depositions. So the other nice thing about inter partes review is the speed. If you do have technologies that are being inhibited by certain patents out there, it's 1 year to final determination. So in that regard, it's going to be quick to get a final determination. What do I have here? When I first looked at what I had written here, the idea was to put up strategies. When I first looked at it, went back and looked at it, I realized I put up a lot of the impacts. So some of the strategies that I'd like to talk about with regard to inter partes review really goes to whether you're on the offensive side or whether you're on the defensive side of things. If you find yourself, like I said, with a technology that's being inhibited by a patent out there, then you may want to go on the offense for inter partes review. And with that offensive strategy, you want to take a look and quickly resolve it, because it is impacting your business going forward, and you want to know what you can and cannot do. So if that patent can be cleared and moved out of the way, you're going to want to do that. So at this point in time, it's important to begin preparation for inter-parties review if you're going to be filing one of these. So that would involve conducting your validity searches and getting your positions formalized as to how you're going to attack these patents. Because once you get into the proceedings themselves, the time period is going to be relatively quick. Also, an important thing to remember if you're going to go this route and go on the offensive side is a limited number of these proceedings are going to be instituted. Again, the Patent Office is worried about being overwhelmed, so having all your ducks in a row at the time this kicks in 6 months from now will allow you to be one of the people that do get involved in these proceedings if you need it. On the defensive side, if you're worried that you may be subjected to by one of your competitors to an inter-parties review and you want to avoid that, it's very important to get your patents filed before the first inventor to file rules take effect. Here with inter-parties, it's not as important right now, but with post-grant review, it's very important because that's the only way post-grant review can be applied. So in that regard, again, it's going to come up when we talk here in a minute about first inventor to file, that you need to get the patent applications on file. We're starting to get a little bit into timing issues, so I wanted to just briefly talk. I did talk about post-grant review here, briefly to say that is going to kick in down the road. We do plan on having future presentations on what to do now in view of post-grant review, or rather what to do in the future. So we will address that more particularly as we approach that time frame. I also have in the presentation materials some variances between post-grant review and EPO oppositions. So if you'd like to see some of the contrasts, if you've been involved in an EPO opposition or you're interested in what happens in an EPO opposition, we do have those materials in there for you to take a look at. Again, I'm going to, in the interest of time, just move along and get to the final couple of topics we have. Priority examination of important technologies. The AIA allows the director to give priority to some applications over others. These would be applications where the technology is deemed to be important to the national economy or national competitiveness. The nice thing about this is the director does have the authority to do this without recovering the fees or the extra costs that would be involved. The unfortunate side of this from a strategy standpoint is we have no indication what those technologies are yet. So we're in a wait and see situation. We don't know, even if it does get impacted, whether accelerated examination rules are going to apply. Some of those are pretty onerous. For example, the pre-examination search and the discussion of those results, as well as the extensive examination support document, which typically we hate to say things against our patents, and that could be a situation where you have to do that. First inventor to file takes effect basically a year from now, and that is one of the biggest changes that we're seeing in the law. The U.S. system is the first inventor is entitled to the patent, but under the new system, the first inventor to file will be the one entitled. Again, I always like to stress this regardless of how many times I've said it. It's not a first to file, but rather a first inventor to file. There are many novelty bars involved in this. Now, because of the effective date of your filing is going to trigger it, so prior art's going to come in under 1 or 2, whether it's patented, described in a printed publication, in public use, which is now anywhere in the world, not just the U.S., on sale bars also is applicable, and that's, again, anywhere, not just in the U.S. And then the caveat, the big catch-all at the end there is otherwise available to the public. With this first inventor to file, there are some exclusions and exceptions. One, disclosures by the inventor are going to be a limited grace period of 1 year. The other way to think of this is if there's a disclosure that goes on and that disclosure originated from the inventor, then the inventor is also going to have that exclusion. So the effective dates again are March 16th, which is a year off. But it's not too early to start thinking about what should we be doing now regarding first inventor to file. the first inventor to file strategies that I think we should take a look at are what I call basically we need to clean out the attic. If your inventors have invention disclosures that are already filled out and sitting on the shelf because it's not a pending technology or something that's being implemented, we need to get those invention disclosures to the review committees so that they can be acted upon. We also need to have the inventors to, if they have ideas that have been sitting around their head, they haven't put them down to paper or they haven't memorialized them, they haven't got those in front of the review committees, we want to see that happen as well. The reason being, first inventor file, yes, it's a year off, but as we all know, that year is going to fly by us. So the idea here is there's a lot of benefits to being under the current system from prior art. Let's start the ball rolling. Let's start to get these disclosures in front of the review committees, and let's have them looked at. From the review committees themselves, they're going to have to start meeting earlier and more frequently to make sure these are cleared. And then in a long-term process, the internal processes need to be taken a look at to make sure we don't have any unnecessary delays. Scheduling metrics both on the internal side and on the external side for your outside counsel, I think, are very important. So another thing to do because of the timing is to make sure that your invention disclosure forms are complete and have all the information that your committees need to make these decisions. So we recommend that you go back, take a look at your invention disclosure forms, make sure it does have all the information. Also, take a look at your review committee. Is it a multidisciplinary approach? So you have a little bit of everybody that can say, is this technology worthwhile? Here, do we have R&D involved in engineering? Is management involved? Is it staying in the business strategy? Obviously legal involved, as well as consider whether or not you should be bringing the inventors into those review meetings so that they can answer questions right there on the spot about the technology and make sure that we're proceeding quickly to get the invention disclosures reviewed and start the process rolling. Additional procedures down the road would be the filing, obviously, and then we'll talk more as we get closer to the kickoff date, whether or not you need to implement a provisional filing strategy to make sure that you got as many technologies under the current existing law. Derivation proceedings also come off into effect here about a year from now. These will be replacing interferences. Interferences are not a mechanism that's used a lot. 100 petitions, I think, were filed last year, and about 50 of those were instituted. So you can see it's not a really big lot of cases that'll go under this. However, it's going to be a while before this kicks in again, because derivations also come under the new law. The big thing for a strategy standpoint on derivations is that derivation, again, is another who files on your inventions. So here we want to start thinking about strategies for monitoring what we are disclosing and who we're disclosing it to. So for example, if we're in joint development efforts, we want to be monitoring for publications by our developers, by our vendors, and for former employees. That's going to allow us to see whether or not a derivation proceeding should be instituted. We're about out of time. I think we wanted to, one, thank you for coming, and then we wanted to open the floor for questions. So I think we have a few questions that came in, and so I'll turn it over to Tim.
Well, Eric, let me throw you the first one that we've received here. What is going to be the scope of the discovery and trials before the Patent Trial and Appeal Board on the new post-grant proceedings?
Well, the scope of discovery in these proceedings is currently just in the proposed stage. One of the things is primarily if you're going to be submitting affidavits and supporting documents for your positions on why a patent's invalid, anybody signing those affidavits is going to be subject to depositions and testimony in that regard. So that's the biggest place where the scope. Again, how far they're going to let it go under inter-parties review, there's a provision that says as necessary in the interest of justice. So that's a rather open-ended statement right there, and we're going to have to see how that gets reined in completely. So it's definitely going to be a broader expanse. than what we've seen in the past. It will be a very different procedure down at the Patent Office, but exactly how broad that interest of justice goes is still an open question.
I'll handle the next one. The next question submitted was, what aspects of PTO rulemaking have been most controversial? And I think everyone would probably agree it's the fees. There's lots of fees. I mean, re-examination, we used to be pretty cheap in terms of fees. Now the PTO has looked at it and done a lot of cost studies to try and figure out what these things really cost, and understandably are trying to, a big battle in the Patent Office is trying to hold on to their money and make sure they have enough money. But right now the fees are a big issue, I think, and a big controversy. When you're talking about some fees, getting close to $100,000, that opens up a few eyes. Do we have time for a few more questions? Or okay, another question for you, Eric, is what is the single most important thing that people concerned with the strength of their portfolio, what should they be doing now?
Well, I think with the implementation of First Inventor of the File, to give you the broadest possible scenarios for getting your patents issued and limiting the prior art that can be applied against it, is to get the applications that you currently the technologies you're currently aware of on file before the year runs up here. So by doing that, we've got a little bit more arguments we can make on the patentability side, limiting the prior art in certain instances. And so I think that's the best way to strengthen and broaden the scope of protection that you get out of your portfolio, or at least the future portfolio that you would have.
Okay, we have one last question. What is the single most important thing that people concerned with patents of the competition should be doing right now? Well, I think, as I told you earlier, if you're thinking about re-examination, you should be thinking immediately about filing an inter partes re-examination, because they're going away in September, they're not coming back, and there's a lot of advantages to them over the inter partes review, which will be in place in September. And you should also start getting up a system for putting things into the patent files of your competitors. Pre-issuance submissions, the citation of materials in a patent that already issued. You should start thinking about attacks on their portfolio that you're going to be able to start doing in September that are not currently available. But it's only 6 months away, and you're going to have, if you file a slew of these things in September, you can create some real problems for your competition. So with that, I think we're concluded. Thank you all for attending.
Yes, thank you.
And we appreciate your attendance. Thank you.
This concludes our presentation. Don't forget to download our panelist biographies and the presentation before you tune out. And note that your CLE certificate of attendance will be sent within 10 business days. Thanks to everyone for joining us.